But आपने एक एप्लीकेशन बुक किया था 156 अलाउ किया एंड दी कोर्ट ऑर्डर रजिस्ट्रेशन ऑफ एफआईआर एक गलती थी 30/9 का वो ऑर्डर था दी एफआईआर इज रजिस्टर्ड आफ्टर 18 days 18 days बट अब एफआईआर रजिस्टर हो गई है इन द मंथ ऑफ अक्टूबर एंड आफ्टर दैट द इन्वेस्टिगेशन इज गोइंग ऑन क्या स्टेटस क्या है इन्वेस्टिगेशन का Not on the last date, this honorable court was, the coordinator bench was pleased to call the IO. I also inquired a lot. He is inquiring. Till date, charge sheet is not filed or the final report is not filed. And आपका दूसरा जो ग्रीवांस है वो ये है कि आपके द्वारा बताए गए सेक्शंस में एफआईआर रजिस्टर नहीं हुई. If my lord will be kind enough to consider the order passed by the magistrate while passing and allowing their 156(3) application doesn't speaks of any section. उनने सिर्फ ये the order speaks that जो भी आप 1 से लगाए 6 तक के विरुद्ध प्रथम सूचना रिपोर्ट दर्ज करें और अपराध पाया जाता है या नहीं पाया जाता है नाउ दे वांट कि हमारे बताए द्वारा वाले सेक्शंस में ही आप रजिस्टर करें. They may show any order because directing registration of FIR in certain sections which they feel like. My humble submission is not now. Nothing survives in this petition because the FIR is also registered. Investigation. FIR की तारीख क्या है?
FIR is P16, page number 128.
Date 19/10/24.
19/10/24.
Yes.
And this order of magistrate is dated
30th of September, 3/39/24.
39/24.
What is his relief?
No, the investigation may kindly be transferred to any senior police officer, my lord. I may kindly be heard. I have very this case requires a lordship kind analysis, my lord. It is an exceptional case, my lord. My lord may kindly refer to the order passed by the magistrate on page number 125, P13, my lord. My lord, there was clear direction to register the FIR against the accused person, my lord. P13, my lord, 13, page number 125. There is this clear direction that so and so accused against me register an FIR, my lord. Now, my lord, P14 is the letter issued. Yes. May I read the relevant paragraph? Yes. Now, my lord, P14 is the letter issued to the concerned police station directing them to register the FIR dated 30th September. On the same date, my lord, the magistrate issued a letter to the concerned police officer to register the FIR. Now, my lord, despite the communication of the magistrate court, despite there being a clear direction to register the FIR, no FIR was registered, my lord. Being agreed, my lord, I moved an application to the SP, which is annexure P15, my lord. When I inform the SP that so and so order has been passed by the magistrate, kindly direct your concerned officers to comply with the court's order. This is dated 7th of October or 9th of October. But your officers are not registering my FIR, and in this very case, seizure is to be made. So there cannot be any delay in registration of the FIR, my lord. Despite this, my lord, no direction was given to the concerned police officer, my lord. Now, my lord, finally, after a period of almost 19 days, the FIR was registered, my lord. Now, my lord, the FIR was supposed to be registered based on the allegation I mentioned in my complaint, my lord. And the allegations was that of dacoity, my lord. But to give the benefit of the arrest to the accused, the case has been registered for offense of theft, which is punishable up to 7 years. Now, my lord, being agreed by the FIR that firstly that there has been delay, and secondly the FIR is deliberately registered under the weaker provision of law, I moved an application before the magistrate for monitoring of the investigation. Said application is annexed P17, my lord. Now, my lord, interestingly, the magistrate issued a letter to the concerned police officer asking an explanation that why there has been delay in registering of the FIR, my lord. Now, my lord, their explanation may kindly be seen. It is annexure P20, my lord, on page number 158. May I read the explanation?
Yes.
I'm sorry, my lord, it's P22, page number 160. Their explanation. प्रकरण संलग्न दस्तावेजों को अवलोकन करने से प्रथम दृष्टया यह स्पष्ट हुआ कि उक्त प्रकरण सेल प्रवृत्ति का है। इसे फरियादी सोनसो द्वारा फौजदारी प्रकरण बनाकर प्रस्तुत किया है। Now, my lord, what my humble submission is that an investigation is commenced once the FIR is registered, my lord. Without even registering the FIR, they are running a parallel court and declaring that the case is of civil nature, my lord. How can it be expected from this person that they will conduct a free and fair investigation, my lord? When they have already make up their mind, even without registering the FIR, without even commencing the investigation, they're submitting before the court to civil nature ka hai. When the magistrate court has directed them to register the FIR after considering all the documents, they are not the one who should apply their mind and give the submission that case civil nature ka hai. That too without commencing the investigation, my lord. If during the investigation, if they find such material, they could have filed a khatma, my lord. But without registering the FIR, my lord, if they are submitting this, it means that they are interested.
What was the incident? What happened?
Well, what had happened in this case is, my lord, for the property of the petitioner was demolished by the respondents, my lord. The goods of the petitioner kept in the property were forcefully taken before the petitioner, my lord, and he was threatened to that if he tried to stop them, my lord. This was the allegation that मेरी property को dismantle किया है and they took away my goods, my lord. And they were more than 5 people. So it's an offense of dacoity, my lord. And they have deliberately registered the case for offense of theft, my lord. Now, my lord, delay in registration of the FIR, my lord. After a direction under section 156(3), this very issue was before the Honorable Calcutta High Court, my lord, though it's not an issue. But since similar issue was before the Honorable Division, may I kindly read just 3 paragraphs from the judgment. The highlighted paragraphs. However, where the judicial authority issues direction to register of FIR under section 156(3) of the CRPC, requirement to hold preliminary inquiry is obviated and it is mandated of the law that such FIR be promptly registered. Failure to do so constitute a constitutional tort arising out of breach of the fundamental right of access to justice for victim of crime, and action ought to be taken against erring police officer provided in para 126 of the report. Accordingly, Director General of Police, State of West Bengal shall ensure initiation of disciplinary proceedings against Sri so-and-so, the inspector in charge of so-and-so police and so-and-so persons and other police officer who may be responsible for aforesaid breach, and submit report with that regard to the fate of such proceeding on next date of hearing. In order to ensure that such breaches of statutory duty do not occur in future and the constitutional obligations to uphold the rule of law, we promptly registering FIRs pursuant to direction given by the magistrate under section 156(3) of the CRPC are effectively enforced. We direct as follows. Under
Yes,
as it has been misstated before the Constitutional Court that without registering on FIR and application was moved before the Honorable Magistrate, the FIR is registered on 1910. The letter which my friend just read.
But why this
for 1111?
Why he has stated?
Just one more thing, Manoj. When they have initiated a monitoring of FIR case before the magistrate, what made them to approach this honorable court are that proceedings still pending, or they have been decided and finished off? At least they should apprise this honorable court that are they carrying out parallel proceedings?
So it appears that they have not gone through the petition, my lord. That has been. I'm sorry.
Yes.
So. And my lord, the FIR was directed to be registered. The FIR is registered and investigation is going on. Of course, they are aggrieved and hence they approached under 156(3) because there was their application was not considered.
Why this police personnel was exercising his discretion that it is
after some investigation what he has written. Because
it
is an internal communication. But till date, what would have been, I can just submit before my lord that till that day, whatever the material would have been record, he has written it, and it is an internal communication. He has written this to the magistrate. Still, he has not filed the final report, Lord. And if at all he files a final report and they are aggrieved by the final report, they can very well protest. But the grievance they are agitating before this honorable court is they want arrest of the accused persons. That is their case in entirety, my lord, to create, if I may say, pressure.
दिखाइए यार केस डायरी दिखाइए तो अभी तक क्या किया है आपने दिखाइए ये उसका क्या नाम
What my expertise understand is that firstly, this is not a petition where I'm seeking any sort of arrest. This is a petition where I'm seeking transfer of investigation to any senior police officer. And also, my lord, so far as the monitoring of investigation is concerned, my lord, the honorable court is being misled by the opposite counsel, my lord, because I mentioned in my petition that application has been closed and they have been warned कि ये गलती करी अब गलती दोबारा मत करना. But still, this investigation is with them, my lord. And my lord, interestingly, my lord, they have filed a reply. And in their reply, my lord, they submit that उन्होंने पहला statement दिया on 10th of November 2024, my lord. That is after a period of 20 long days from the date of registration of the affair, my lord. Now, my lord, there are plethora of judgments on this very point. The delay in registration of 161 statement can be fatal for the prosecution, my lord. So they are deliberately making the case of the prosecution weak, my lord. From day one, they are submitting that ये तो civil case है. How can it be expected that this person will conduct a free and fair investigation with an open mind? When without even commencing the investigation, they are running a parallel court and declaring that this is a civil matter. That's why we did not register the FIR promptly. And my lord, may I refer the honorable court to their reply, my lord. Page number 13 of their reply, my lord. My lord, ऊपर स्वतंत्र साक्षी लिखा हुआ है, उन्होंने 161 कथन लिए हैं, and it appears more of a defense witness sort of, कि they are recording defense witness, कि कोई प्रकरण नहीं बनता है. अब स्वतंत्र साक्षी में kindly peruse the name, किसने स्टेटमेंट दिया है? कैलाश चंद्र पिता रामप्रसाद सोनी, and the accused is रामदयाल सोनी, निवासी लाल खिड़की, and he is निवासी लाल खिड़की. इनके घर के लोगों का स्टेटमेंट ले रहे हैं, ये कहते हुए कोई ऑफेंस नहीं बन रहा है, क्योंकि घटना ही नहीं हुई है. And he alleged कि मैं magically from my home, date of incident पे at the occurrence spot में आ गया, and मैंने घटना देखी. इनके घर के लोग स्टेटमेंट ले रहे हैं एज ए डिफेंस विटनेस बनाओ. Also, may not there was supposed to be Caesar. Caesar का इन्होंने क्या किया अभी तक? They may kindly be asked. And 156(3) का जो ऑर्डर है, उसमें क्लियर डायरेक्शन है कि इस मैटर में आपको सीजर करना है. If there will be this much of delay, my lord, the seizure will be affected, my lord.
ठीक है अल्फाज.